Thanks very much. Hi, everybody. Pleasure to speak to you today about the Temporary Foreign Worker Program. So the Temporary Foreign Worker Program, it's a shared program. The mandate is split between my department, the Department of Employment and Social Development Canada, and CIC, and we also have a role for the Canada Border Services Agency. It's a program that is there to facilitate the entry of foreign workers for employers that have short-term temporary labor gaps so that they can access foreign workers on an as-required basis. Two of the foundational principles of the program. One is to ensure, first and foremost, that the Canadian labor market is protected. And by that I mean where Canadians are available and qualified to work in Canada and access jobs, they need to be given priority. That's that's the core foundational principle of the program. Second foundational principle is when a temporary foreign worker enters Canada for work, they need to work at a Canadian standard. They need to be treated to a Canadian standard by employers. They need to be treated as we would expect Canadians to be treated in any job site, in any labor situation. And so in issuing a labor market impact assessment, essentially the product that ESDC issues under the program, we are holding employers to commitments around wage, around working conditions, around the things that are important to any work situation. That labor market impact assessment that we issue supports CIC in issuing a work permit, or ESDC, CBSA in issuing work permits at ports of entry. The program has obviously been the subject of a lot of media coverage in recent years, and a lot of public commentary on the entry of foreign workers. Anybody there are, for every 10 people, there's probably 11 different opinions on how to address the issues that are raised by this program. But all of that public discourse, the media attention, the political discourse around the program has led to a series of reforms over the past few years. The first major set of reforms that we introduced was in 2011. And what we did in 2011 was we looked at, we wanted to go beyond the assessment of labor market factors as was required by the Act and regulations then, and look at the genuineness of the job offer. And that was really about an employer's ability to support the wages of a foreign worker, about an employer's actual engagement in the kind of business that they say that they're in, and their ability to demonstrate that they're in compliance with federal and provincial employment regulations as they may apply. We also looked at cumulative duration in 2011, and what that means is that we wanted, and this was more of a CIC initiative, but we wanted to ensure that temporary foreign workers arriving in Canada, particularly in low-wage, low-skill occupations, didn't have unrealistic expectations with respect to the permanent status of their employment as temporary foreign workers. The cumulative duration is really about ensuring that temporary foreign workers remain temporary and that there's not an ongoing cycle of temporary work within Canada for any arriving temporary foreign worker. We also, in 2011, started employer compliance reviews in earnest, and this was a new feature to the program that was probably lacking for far too long, but we started a process where we could assess an employer's compliance to the terms and conditions of the labor market impact assessment, used to be the labor market opinion that we issue. So an employer's compliance to, at that time, wages, working conditions, and the job duties in the occupation. In 2012, the Economic Action Plan mandated the government to undertake a comprehensive review of the program, and we started a number of policy initiatives and consultations to the broadest scope of stakeholders you could imagine to better understand the concerns with the program and what needed to be fixed. And that led to reforms in 2013. The reforms in 2013 were spurred by some individual cases where there were concerns raised about the program, but essentially we suspended the accelerated labor market opinion process, which was a process that depended more on attestation and employer commitment than it did on our ability to assess upfront what the nature of a job offer was. It required that by and large, and only in the minimum exceptions would we accept otherwise, that employers could require foreign workers or Canadians to speak a language other than English or French, the two official languages, on a job site. We brought in place the fee. At that time, it was a $275 processing fee, $275 per worker requested under an LMIA application. And we also enhanced our authorities with respect to employer compliance and introduced ministerial instructions. Ministerial instructions are particularly important in the new program, and I'll talk about the new changes in a second, because it provided the Minister of Employment and Social Development with the authority to bypass the regulations with respect to our obligation to process applications and our obligation to issue a labor market impact assessment, irrespective of the circumstances. So that led to the TFWP, the Temporary Foreign Worker Program overhaul, the changes for which were announced on June 20th of this year. The announcement was important not only for the Temporary Foreign Worker Program for itself, but also for the broader immigration considerations. And with that, we introduced the International Mobility Program as a sister program to the Temporary Foreign Worker Program. International Mobility Program is really the compilation of international agreements such as NAFTA, such as student exchange agreements, that lead to temporary foreign workers entering Canada without a labor market impact assessment. The reason we can do that under the International Mobility Program is because a lot of the labor market factors that we consider that would lead to a positive impact on the labor market are implied by the agreements that Canada signs. So we have quite a large consideration of temporary foreign workers that enter under the IMP without a labor market impact assessment, because we know that it's implied that there will be a benefit to the Canadian labor market from their arrival. The remainder, which is still roughly about 38% of temporary foreign workers that enter Canada, come in under the Temporary Foreign Worker Program, and that's where the labor market impact assessment that we issue is required to support the work permit. The Temporary Foreign Worker Program reform had three main pillars, and I'll go through each of them. Restricting access, ensuring more and better use of labor market information, and stronger enforcement. So restricting access. The foundational element of restricting access to the Temporary Foreign Worker Program is moving from looking at jobs in terms of high skill, low skill, to high wage and low wage. It was felt that that's a better determinant of a worker's vulnerability in the Canadian economy and the Canadian labor market. So we moved from we still use the National Occupational Classification as a framework for understanding any kind of job offer in Canada. But in terms of assessing applications on the basis of the vulnerability of the worker, we use the dividing point to be the provincial median wage for any occupation, and then we assess the wage offered by the employer against that provincial median to determine whether the application will be assessed with enhanced worker vulnerability, enhanced worker protection requirements, such as paid air transportation and that kind of thing on the part of the employer, or as a high skill, high wage occupation where some of those requirements on employers are slightly relaxed. We increased the fee from $275 to $1,000. That was to reflect program costs related to enhanced employer compliance measures. We also determined that there were a number of situations under which we would no longer issue labor market impact assessments to employers. We wouldn't even accept an application, and that's in certain occupations to do with food services, where low wage, low skill domestic labor should be in reasonable supply, and we've determined that that's in areas of unemployment of above 6%. We also reduced the duration of LMIAs for low-wage positions. Previously, an employer hiring a low-wage foreign worker could have that worker come in under a single LMIA for 2 years. We reduced it to 1 year out of recognition that low-wage foreign workers should be truly temporary, or should find the pathways to permanent residency as they exist, and that labor markets should be able to adjust to low wage, the availability of domestic low wage labor, particularly in the majority of Canadian markets where unemployment is above 6%. The second pillar that I want to speak to about our program reform is ensuring more and better labor market information. So we are developing the Job Match service. The Job Match service is going to ensure that employers applying for temporary foreign workers are able to draw on data and applicants to the Job Match service, where we're able to match people looking for jobs through Canada's Job Bank or through other private job match services available to an employer's employment offer that they post on the Job Bank. This matching service is going to be key to understanding, at least in terms of on-paper skills and on-paper availability, what domestic Canadian workers are available to employers prior to an employer applying for foreign workers. We're working with Statistics Canada to develop two important surveys, the Quarterly Job Vacancy Survey and the Annual National Wage Survey. Those surveys are going to develop for us key labor market information that we haven't had access to in the past, the government hasn't funded in the past, and this is going to allow us to do much better work in terms of assessing individual applications on the basis of what these surveys show in terms of job vacancy and wage rates. We also want to make better use of existing government data, and that's drawing better linkages within our own department between our program and the employment insurance program, so that we can better plot where the availability of Canadians are at various skill levels and various occupations, and use that information to better assess applications, and also to work with employers to better understand what their opportunities are to hire domestically before hiring foreign workers. Last area that I want to touch on is stronger enforcement. This program has never had penalties before for employers that don't honor their commitments under a labor market opinion or a labor market impact assessment. We haven't had effective enforcement mechanisms to date. So the government has put in place measures to increase this significantly. One of the things that we want to do is go from assessing about 1 in 10 employers through employer compliance reviews to undertaking inspections, which are a much more rigorous look at an employer's compliance, for 1 in 4 employers that apply to the program every year. We're also going to be looking at all of the conditions of a labor market impact assessment. We're going from 3, where it was wages, working conditions, and the occupation description that an employer had to comply with, to all 21 factors under a labor market impact assessment. We have some measures in place now for increased detection and monitoring, and what the factors that lead to undertaking an inspection on an employer can be a lot of intelligence that comes from the media, that comes from foreign workers or other employers themselves that may have information that suggests that an employer is mistreating or foreign workers are not making good use of the program. For that, we have the Service Canada Confidential Tips line, as well as the online fraud reporting tool. Better information sharing is a key piece, so working with law enforcement agencies so that when there is evidence of fraud or misuse of the program, we can report that information better, and if there's a criminal element to it, enabling our law enforcement agencies to better investigate and prosecute where required. And then lastly, more severe consequences for employers when they misuse the program. We're going to be implementing administrative monetary penalties, which will subject employers that are found to be in willful noncompliance or noncompliance without justification, subjecting them to monetary penalties that will ensure that they do understand that they've misused the program and that won't be tolerated, as well as bans from the program and publishing employers' names when the program is willfully misused. Going forward, we want to continue to engage stakeholders in outreach on this program. We want to make sure that employers using the program understand their obligations, understand the program. We want to make sure that temporary foreign workers are still accessible to employers when there is a true need. But we also want to ensure that employers understand their obligations and understand the consequences of not fulfilling those obligations. We're going to reintroduce the Temporary Foreign Worker Program web service, which is a key service delivery tool that we have had in place in previous years, but one which is now being significantly upgraded and adjusted for the new program requirements so that we have a really effective online tool for applications and program delivery. We also have some legislative proposals that are that were published in the Budget Implementation Act to make some adjustments to the legislation to better reflect the new direction of the program, and also to put in place some new measures that were announced in June, such as a privilege fee for employers wanting to use the program. The privilege fee, of course, would be on top of the processing fee that we already charge right now. So, to summarize, we have a program that has gone over the last 4 years, significant change, and I think that's been laid out here quite clearly. The change has been around worker protection, employer compliance, ensuring the program is used correctly. It's really to respond to a lot of the public discourse that has leveled criticism against the program for not effectively, in all cases, protecting the Canadian labor market and ensuring that foreign workers in this country are treated as they should. So moving forward, it's going to be now a lot about refining our program implementation, refining the applications process, ensuring transparency, and working with employers to make sure that the program is still accessible, but really supporting the new measures through our employer compliance review process and inspections, and ensuring that the program is as effective as the design suggests it should be. Thanks very much.